Fundamental rights in the Constitution are present in Part 3 of the Constitution, which are from Article 12 to Article 35. They are also borrowed from American Constitution. In American Constitution, they are known as Bill of Rights. The name fundamental has been given because they are present in Constitution, which is the fundamental law of the land, and also they are fundamental in an all-round development of an individual. Now, these are the features of the fundamental right. First is availability. That means some fundamental rights are available for both the citizens and foreigners, whereas some fundamental rights are available only to the citizens. The second is some rights are not absolute but qualified. That means the state can impose some restrictions. Under Constitution, they are called as reasonable restrictions. So whether these restrictions are reasonable or not are decided by the courts. And the third is justiciable. That means any violation of the fundamental right can be challenged in the court. And the next is they are not sacrosanct or permanent. That means the parliament or only the parliament can amend or they can curtail or they can repeal the fundamental rights by constitutional amendment and not by ordinary law. Next, they can be suspended during national emergency. And the fundamental rights are restricted to armed forces, paramilitary forces, police forces, and intelligence agencies. That means the rights which a normal citizen is having is not available to the men in armed forces and paramilitary forces or police forces, etc. Now coming to the next part, that is Article 12. So before diving into what fundamental rights are, it is important to know what Article 12 and Article 13 is. So first we'll know what Article 12 is. Article 12 defines state. Now why it is important to define state is in fundamental rights there are a lot of times it has been mentioned as state. So in normal terms, state means the states like Karnataka, Maharashtra, that is assumed by the people, but in the constitutional terms, the state defines all these four categories, that is the government of India and parliament, the government of the state and legislature, and all the local authorities like municipalities, panchayats and district boards and other improvement boards, etc. And all statutory and non-statutory authorities like LIC, ONGC, SAIL. The statutory authority means any authority that has been created by an act, and non-statutory authority means any authority that has been created just by the executive order, etc., and not part of any act. So if these four make any law which violates the fundamental right of any citizen, then that citizen can challenge that law into the court, and they cannot challenge anything except if any law is done outside of these four conditions. Article 13 defines what is law. That means now a citizen, if any law that violates the fundamental right, then the citizen can move to the court, right? But what is the law? So against what law a citizen can go to the court is mentioned in Article 13. So these are those laws, that is permanent laws enacted by parliament or state legislature, that is the normal bills which the parliament and state legislature pass and which become an act. So against those laws. The second one is the temporary laws. That means the ordinances issued by the president or state governors. Now delegated legislation Now what is delegated legislation? Now delegated legislation means we have seen that we know that the lawmakers in parliament and state legislature pass the bill that in becomes an act, but this act contains only a broader framework of any part of any piece of legislation. That means it is in its skeletal form. Now what happens is then the government makes rules and bylaws and regulations or notifications, etc., and then they can be implemented. So that is all about delegated legislation. They are also called it subordinate legislation, and there are other different names are there. And next is non-legislative source of law. That means, for example, judicial precedents. So judicial precedents is non-legislative source of law. Then the constitutional amendments, which violates the fundamental right that forms a part of basic structure of the constitution. So this last part was not present in the original constitution. This has been added later on. So if these laws violates any fundamental right of any citizen, then the citizen is having the right to go to the court. So these are the fundamental rights. So Article 14 to Article 18 comes under right to equality, and then further right to freedom, right to, then this Article 19 to Article 22, the right against exploitation, Article 23 and Article 24, right to freedom of religion, Article 25 to Article 29, sorry, Article 28, then cultural and educational right, Article 29 and 30, then right to constitutional remedies, Article 32. Now we'll see the first one, which is right to equality. Now the right to equality, as we have seen that it is there from Article 14 to Article 18. So this is Article 14, which is equality before law and equal protection of law. Then this is Article 15, this is Article 16, Article 17, Article 18. So we'll see further in detail about these articles. So this is Article 14, which is equality before law and equal protection of law. Now in this article we have two parts, that is, first one is equality before law and the second one is equal protection of law. So this article says that is equality before law says that the state shall not deny any person equality within the territory of India. That means no matter if you're rich or poor, no matter if you're an officer or non-officer, if you're from high caste or low caste, doesn't matter, everyone is equal before the law. And the second provision, this article also confers rights on all persons, whether citizen or foreigner. As we've seen earlier that in the features, that some rights are available only to the citizens and some are available for both the citizens and foreigners. So Article 14 is available for both the citizens and foreigners. So let us dive deep into it. So equality, this is having two parts, equality before law and equal protection of law. So equality before law is a negative concept. Now why it is called as negative concept is, under this everyone is equal before the law, no matter, as we said earlier, no matter if you are rich or poor, no matter if you belong to upper caste or lower caste, doesn't matter, you are equal before the law. That it is called negative because there's no special privilege for any person, everybody is equal. But in the case of equal protection of law, it is called as positive concept because some section of the society is having some special privilege which the other section of the society is not having. For example, in our country, SC, ST or OBC, so they are having reservation. They are having reservation in colleges, they are having reservations in employment, etc. But the same is denied to general category people. Okay, so now general category people cannot go to the court and say that my Article 14, that is equality before law, is being violated, because the Supreme Court has said in one of its judgment that likes and unlikes cannot be treated equally. That means the two sections of the society which are different cannot be treated equally. In this case, in this example, if you see that SCs and STs and the lower caste, so-called lower caste people, they have been subjected to a lot of atrocities in the past, and to make sure that they are getting equal representation in education and jobs, they have been given reservation. So that is why it is called as positive concept. So these are some exceptions to equality before law and equal protection of law. Now, as we've seen that equality before law says that everybody is equal before the law of the land. But again, there is an exception. That means there are few categories of people who are exempted from such equality. That means they have some special privileges. Who are they? They are the president and governor. So they enjoy immunity in some matters. And what are those immunities? For example, in civil cases, no proceedings can be initiated against president and governor if the authorities, the government authorities, want to initiate any civil proceedings, or the courts, if they have to initiate any civil proceedings, then they have to give 2 months prior notice for them. And same in the criminal case, matters also. No judge, no authorities or courts can initiate any proceedings against president and governor. That means they are free from any kind of criminal proceedings, and they can all be jailed also. So these are some privileges that president and governor is having, which a normal citizen does not have. That is why they are exceptions. Now another case is no MP or MLA is liable to any proceedings in any court in respect of anything said or any vote given by him in parliament and state legislature respectively. That means that now we have seen in TVs and all that MPs and MLAs, they debate in parliament and state legislatures, and they also vote on different matters. Now any citizen cannot go to the court and say that his or her fundamental right is being violated by anything that is said by an MP or MLA in the parliament or state legislature, or any kind of vote given by him. So they are also exempted. The third condition is Article 31C. So Article 31C says that if any law seeks to implement few provisions of directive principles of state policy, then they cannot be declared as void or illegal, saying that they violate Article 14. So that is there all about Article 31C. The next condition is the foreign sovereigns. That means the rulers, like Saudi Arabia's rulers are there, some Middle East rulers, or the presidents and prime ministers of different countries. If they are in India, they are exempted from, they cannot be treated equally like other citizens. They have some special privileges. And also the ambassadors and diplomats of other countries, they are immune from any civil or criminal proceedings. And in the same way, the United Nations organization, its agencies are, again, they enjoy diplomatic immunity. No person will be liable to any proceedings in any court for publishing true report of parliament or state legislature. So if any person publishes true report of what was going on in the parliament or state legislature, they are also exempted from any kind of proceedings. Now this is Article 15. Under Article 15, the state shall not discriminate against any citizen on grounds only on race, religion, caste, sex, and place of birth. So what does this article mean is that here there are two words which are very important. That is, first one is discriminate. That means one section cannot be given special privilege over the other section, or one person cannot be given special privilege over the other, and only on the grounds of race, religion, caste, sex, and place of birth. That means on any other grounds other than these included in this, discrimination can happen. So that is what is mentioned. So in the other provision, it says that no citizen shall be subjected to any disability, liability, restriction, or condition on grounds of only of race, religion, caste, sex, or place of birth with regard to access to shops. That means no citizen shall be subject can be stopped or restricted from on the grounds of, again, race, religion, caste, sex, place of birth, access to shops, public restaurants, hotels, or places of public entertainments. That means any citizen cannot be stopped from entering these places. And also the use of wells, tanks, bathing hearths, roads, places of worship, places of public resort maintained by wholly or partly by state funds. So the crux is that if the state is wholly or partly funding the any kind of uh, public infrastructure, then any person cannot be restricted from entering it and using it. Again, there are some exceptions for Article 15 as well. So the first exception is women and children. Under this, as we've seen earlier, that there are 4 conditions, that is race, religion, caste, sex, and place of birth. If you see here that sex is also mentioned, that means people cannot be discriminated on based on their gender. But here we see that there is an exception, that women and children have been given. That means for the development, no, the state is permitted to make any special provision for women and children for their development, like reservation is given for women in panchayats and municipalities, and for children also some kind of scholarships are given. So there are some special privileges that have been given. And for socially and educationally backward classes of citizens, that is OBCs, so special provisions can also be made for them, like reservation in education institutions and also reservation in employment, etc. Then economically weaker section of the citizens, recently 10% has been given for economically weaker section. So these are the exceptions where discrimination can happen. That means if they are a weaker section of the society, then the state can make provisions to improve their condition. Now next is Article 16, which is equality of opportunity in public employment, which says that no citizen can be discriminated or be ineligible for any employment or office under the state on grounds of only race, religion, caste, sex, descent, place of birth, or residence. Same as Article 15, there also it has been mentioned race, religion, caste, sex, place of birth. Here one extra is that is descent is mentioned. So based on these grounds, no citizen can be discriminated for employment in the state. That means for government jobs. And again, there are some exceptions, that Parliament can prescribe residence as a condition for certain employment. Now this condition is not there in any other state except for Telangana and Andhra Pradesh. What it says is, for example, in Telangana, if any person belong to Telangana itself, then they're having some special reservation in the employment of the in state employment. There is a state government jobs. So residence is one criteria. Then second is reservation of appointments or posts in favor of any backward class that is not adequately represented in state services. So if any backward class is not represented in the state services, then they can also be given reservation by the state. A law can provide that the incumbent of an office related to religious or denominational institution or a member of governing body should belong to a particular religion or denomination. That means any office of any religious or denominational institution should be the office bearer should be from the same religion. So such provision can be made by the state, which does not violate the Article 16, because there are exceptions. State is permitted to make reservation for economically weaker section, again as has been given by Article as 10% by the Parliament. Then comes abolition of untouchability, Article 17. Under this, the term untouchability has not been defined in the Constitution, but it has been given by defined by Mysore High Court, which says that the subject matter in Article 17 is not in its literal or grammatical sense, but the practice as it has been developed historically in the country. So that means untouchability does not mean not literally touching them or something like that. But in the past, we know that the members who belong to SC, the STs category, were discriminated. A lot of atrocities has been subjected on them, and so to reverse that, this article has been included in the fundamental rights. That means any person, if is still practicing this untouchability, then he will be punished. Then abolition of titles. So after independence, no, before independence there were a lot of princely states, and also they were holding a lot of titles like Raja, Maharaja, etc. After independence, when they decided that under Article 18 they brought this right that any kind of title should be abolished. So nobody now should be called as Raja or Maharaja or anything except for the military and academic titles been mentioned here. For example, if anybody is major or captain or colonel, brigadier, even after retirement, they can retain their rank. And also in academic distinction, they can be called as professor, lecturer, etc. And except them, nobody can be called as nobody can carry a title with them, whether a citizen or a foreigner. So it prohibits a citizen of India from accepting any title from any foreign state. So any citizen of India cannot accept any title from the foreign state. A foreigner holding any office of profit or trust under the state cannot accept any title from any foreign state without the consent of the president. That means if any foreigner is also working in India and holding any office of profit or trust under the state, that means under either the central government or either the state government, then he or she cannot accept any title from any foreign state without the consent of the president. No citizen or foreigner holding any office of profit or trust under the state is to accept any present, emolument, or office from or under an state without the consent of president. So again, same here. If any citizen or foreigner holding any office of profit under the government of India or under the government of any state, they cannot accept any kind of gifts or presents or emoluments or any offer for office from without the consent of the president. So this is all about right to equality, and in next part we'll see the next right, that is right to freedom, and the other rights which are present under that.